Good evening. This is John Milburn for Laws 19038, Planning and Environment Law. This is week 9, and this week we're dealing with Planning and Environment Law litigation, civil perspective. You should by now have received the results of your first assessment piece. If you have any questions about the assessment, then please feel free to contact me, or alternatively, and probably better still, raise some dialogue in UCrew. If you've struggled with the assessment, I'd urge you to go back to basics. Have a look at the video presentations that I've provided to you, which are specific to this term. Have a look at my sample document and have a look at Bates, the way he references material in particular. Good luck with your second assessment piece, and I look forward to receiving that. Now, tonight we're dealing with a range of issues, but primarily planning and environment court litigation in a civil sense. And the interesting thing about the Planning and Environment Court is that while it's part of the district court jurisdiction, in many ways it stands separately to it. There are separately constituted judges of the district court who have tenure in the Planning and Environment Court, for example. And also the type of litigation is different. Unlike standard litigation, if I can use that term, litigation in the Planning and Environment Court is meant to be conducted in a way that is fair and accessible. In that jurisdiction, judges are required to conduct the proceedings in a more relaxed manner than in other courts, and they're required to help self-litigants through the process. In some ways, the terminology that is used in the Planning and Environment Court is familiar to me in that it's the same language which is used in the Queensland Civil and Administrative Tribunal, where I'm a member. While the court remains accessible, it's not the case that just anyone can turn up at the Planning and Environment Court, knock on the door, so to speak, and say, I'm here to litigate a matter. You need to consider and overcome the rules regarding standing, or locus standi, to use the Latin term. And standing, in a sense, is whether you have the legal right to be there. I suppose you could put it this way. A court is entitled to ask the question, do you have the right to agitate this matter? To probably best explain that, I'm going to refer you to the notes that I've prepared. And in preparing the notes, it occurred to me that I should try to create a way of doing so that makes it easy to understand. So I've come up with a flowchart. It's not a complete flowchart, but it's a good start. So if we look at the top, standing, ask yourself the initial question, does the common law apply or do statutory provisions apply? You'll find out whether statutory provisions apply by looking at the Act. I guess it's fair to say for the most part, at the federal level, we look at the EPBCA, and at the state level, we look at the Sustainable Planning Act. Now, if you ask yourself, does the common law apply? The next question is, has the common law been affected or altered by statutory provisions? And if so, given that statutes override common law, have a look at the statutory provisions. We come over here, we ask, do the statutory provisions apply? If so, as I've stated, the statutory provisions prevail over the common law. And then we ask ourselves the basic question, is this a federal matter or is this a state matter? If it's federal, look at the Commonwealth legislative provisions. Now you'll see that there's nothing beyond that in my flowchart, and that's simply because I was running out of room. We'll have a look at the state as a parallel. In the state provisions, you need to then ask yourself the question, why are you at court in the first place? Are you bringing proceedings in the Planning and Environment Court for a declaration about a certain matter? Are you asking for a merits review? Are you applying for an enforcement order or are you prosecuting? A declaration is really, in simple terms, a question asked of a court and the court providing an answer. Have a look at section 456 of the Sustainable Planning Act and you'll see that you have an entitlement to be heard. For a merits review, it's a little more specialised. In order to get your foot in the door, so to speak, and have an entitlement to be heard, you need to establish that you are the applicant for the proposed development, which is section 461 of the Sustainable Planning Act, or perhaps that you are entitled to be heard as a submitter, an objector if you like, in relation to an impact assessable development, which is section 462. You'll recall that not every matter involves submitters. It needs to be an impact assessable development. And not every person that has a problem with a proposed development approval or approval with conditions is a submitter. You need to be a person who put in a submission right at the start in order to have the entitlement to seek the merits review under section 462 at the end of the process. So if it's not a declaration you seek and it's not a merits review that you seek in the Planning and Environment Court, you may well be applying for an enforcement order. And under section 601 of the Sustainable Planning Act, you have an entitlement to be heard. The Byrne Brothers case that I've referred you to is an example of that. Are you prosecuting a matter for a development offence in the Magistrates Court? Have a look at section 597 of the Sustainable Planning Act. So you'll see from that that there are a number of different provisions that apply in different circumstances. Tonight's presentation is really designed to be practical in nature. So if you are going to the Planning and Environment Court, you need to know the process. And I'm going to show you a really good way of doing so shortly. But before I do, you'll recall that I mentioned that standing in the state jurisdiction requires you to consider what type of application do you seek. I didn't have that in the Commonwealth jurisdiction, so I'll go through it now. Obviously, we look at the EPBCA, the Environment Protection and Biodiversity Conservation Act. Now, if you're an applicant, if you're seeking an injunction, which is an order stopping something or forcing something, then you must satisfy the standing tests as they are laid out in section 475 of the EPBCA. For individuals, have a look at subsection 6, and for organisations, subsection 7. That's for an injunction. If you're applying for judicial review, then you must satisfy the standing provisions in section 487 of the EPBCA. Now, that section is subject to change. It's a hot section on the Commonwealth's agenda. But for individuals, it's subsection 2, for organisations, subsection 3. You'll note that I said judicial review, not merits review, and there is a basic difference. A merits review is where the applicant asks the court to step into the shoes, so to speak, of the assessment manager and make what we call the correct and preferable decision. It's as if the file is handed over to the judge and the judge says, let me make the correct decision based on all of this material. For judicial review, the court doesn't take the place of the assessment manager who makes the decision in the original instance, but rather in judicial review, the court is concerned about the legality of the decision-making process. That's what judicial review is all about. Finally, in the Commonwealth jurisdiction, if you do not have the standing to sue, bear in mind that you can apply to the Attorney-General for support, and the Attorney-General can provide permission to bring action on his, as it is now, or her behalf. Now, if you go back to that chart that I showed you, the flow chart, in the Planning and Environment Court, you would have seen that you can apply for a declaration, you can apply for a merits review, you can apply for an enforcement order. Let's have a look at the very common one, which is a merits review under the state legislation. You'll recall that there are two groups that have standing to apply for a merits review. Firstly, a disappointed applicant, a developer, and that disappointment might be because the development application was refused or it was approved but on conditions that were not satisfactory. If you're a disappointed applicant for a merits review in the Planning and Environment Court, you need to establish the issue by looking at section 461 of the Sustainable Planning Act, and that provides the basis upon which the application is dealt with to the Planning and Environment Court. Now, watch the time limits. An appeal for a merits review must be initiated within 20 business days. Now that's after the decision notice was given or a day that the decision notice was required to be given to the applicant. So section 461 subsection 2 is dealing with the right or the procedures, if you like, for a developer. Now for a disappointed submitter, bearing in mind it must be for an impact assessable development, section 462 of the Sustainable Planning Act provides the basis upon which that person or that group can appeal to the Planning and Environment Court. But again, watch the time limits. Once again, it's 20 business days after the decision notice or the negotiated decision notice is given to the submitter. So what's the process for commencing a merits review? How do you actually go about doing it? Now, bear in mind, of course, that there are two types of appeals that we're really talking about. One, which we're talking about right now, is an appeal against a decision of an assessment manager where the application is to the Planning and Environment Court for a merits review, so that the Planning and Environment Court can, as it were, take the whole file and say, let me make the decision. I'll do it. I'll make the correct and preferable decision. So the judge in that instance steps into the shoes of the assessment manager and makes the decision. An appeal against the Planning and Environment Court decision is to the Court of Appeal, but only if you have leave of the Court of Appeal. And that's where you must apply to have that leave. Now, commencing the process of the merits review, have a look at section 481 of the Sustainable Planning Act. It sets out the basic rules for lodging a notice of appeal. And it says that you must state the grounds of the appeal and you must comply with the rules of the court. So obviously, you're going to need to know the rules of the court. In your notes, I've provided you with a basic outline of a notice of appeal. Let's have a look at that now. To do so, I'll share the screen once again. You'll see that the applicant appeals to the Planning and Environment Court, and you set out the decision that you're appealing against, and you set out the orders that you seek. So the orders that you seek, for example, and this is just an example of a very basic notice of appeal, you seek an order that the appeal be allowed and the development application be refused, and such further or other orders as the court considers appropriate. In addition to that, you must set out the grounds of the appeal. So you set out the numbered paragraphs. Each ground is why it is alleged the decision was wrong. So number one, the proposed development conflicts with the planning scheme and there is not sufficient ground to justify approving the application despite that conflict. And number two, the proposed development will have an adverse impact on the environment. So there might be other things. Now, if you're thinking of grounds upon which to argue against the decision, then a good way to do it is have a look at the cases that you've read, and that will give you an idea of the specifics that you need to include. So that's a basic notice of appeal, and that's lodged pursuant to section 481 of the Sustainable Planning Act. When it comes to the steps involved in the litigation, let me once again refer you to the excellent material that you'll find in the Queensland Courts website. Once again, I'll share the screen in order to demonstrate this. Here we have Queensland Courts. We've been there a few times during this course. You'll see a special area for the Planning and Environment Court, and one area, steps to follow, is excellent. It basically lays out in simple terms the steps that you need to follow in order to litigate a Planning and Environment Court appeal. This is a merits appeal. Number one, file a notice of appeal. There's a link to the notice of appeal. Follow the link and you'll see the prescribed form. It's a PEC-1, notice of appeal. It'll look a bit familiar because even though I didn't replicate the heading in the document I just showed you, you'll see that it calls upon you to set out the decision appealed against and the orders that you seek. So that's 1, 2, 3, for example. And then the grounds of the appeal, setting out in the numbered paragraphs why the decision is wrong. And that's what we just did before. So that's the notice of appeal, easily filled out. And if you want to see some examples of that, go to a party search in the Queensland Courts website. I showed you that, I think, last week, maybe the week before, and that will give you an idea of how to get to the specific documents. And you'll see many examples of different notices of appeal that the actual initiating document filed in court. Right, so step 1, file a notice of appeal. Step 2, serve that notice of appeal on the other side. There are certain rules that apply to that service, and of course, as there is with filing the notice itself, there are time limits for giving the notice to the other side. Step 3 is apply for a directions order, and a directions order given by a court is essentially the court laying out the basis upon which the litigation is to be conducted. In other words, the court says, you will do this by then, and to the other side, you will do this by then, and lays it out leading up to an eventual hearing. But before we get to a hearing, usually these matters will go through an ADR, or alternative dispute resolution process, and one or more without prejudice conferences chaired by the ADR registrar or other person qualified in those circumstances. There's a link to useful practice hints, and I urge you to have a look at that. ADR is very important in the context of all litigation, but particularly important in the context of planning and environment court litigation. There are without prejudice conferences between the parties, case management conferences, and also joint expert meetings chaired by the ADR registrar. These joint expert meetings are often called conclaves, and it's where the experts have an opportunity with the ADR registrar to work towards having a joint experts report presented to the court. And it is an excellent way of resolving factual issues. Ultimately, the experts come up with a list of things that they agree upon, things that they disagree upon, and reasons as to why they disagree. This process is very user-friendly, and you can even see there a link to the Planning and Environment Court registrar for a mediation booking request. There's also information about what to include in a mediation brief. So have a look at that, because it's got a wealth of valuable information and it's all really well set out. Then, of course, we have a review hearing, a call-over hearing, and then ultimately the final hearing to round out that process of litigation steps. I mentioned in the context of standing that there are really 3 different things that people might seek in the Planning and Environment Court. Declaration, which is answer to a question. Merits appeal, which is what we've been talking about, where the judge replaces the assessment manager and actually makes the decision. Or it might be enforcement hearings. Let's have a look at declarations. A declaration or consequent relief is pursuant to section 456 of the Sustainable Planning Act. And that section sets out the basic rules for filing proceedings for a declaration. Now, a declaration is not a merits review. It's not the court taking the entire case and making an overall decision. A declaration is a statement by the court answering a specific question. The other issue that you might seek is enforcement orders. And enforcement orders are dealt with under section 601 of the Sustainable Planning Act. And it may be that an applicant seeks a combination of orders. The applicant may seek declarations, injunctions, or enforcement orders, even in the same proceedings. So a declaration is an answer to a question. An enforcement order is an order forcing someone dealing with a certain issue, or an injunction is an order where someone is restrained from doing something or is forced to do something, which we call a mandatory injunction. Irrespective of the type of litigation that you're involved in, you may well need and probably will have to engage experts. Expert evidence is critical in the context of planning and environment court litigation. And I mentioned that the ADR registrar may make specific orders in relation to, say, scientific evidence, and the experts, quite possibly, will be required to engage in a conclave, which is this meeting under the auspices of the ADR registrar. Also, the registrar may give directions to the effect that the experts give their evidence to the court, one after the other, etc. Now, the other thing that you may seek in the Planning and Environment Court is an enforcement order. And bear in mind that regulatory authorities have three different options, essentially, when it comes to dealing with enforcement of an environmental or planning and environment issue. The first is that they can issue an administrative order. The second is they can take civil remedy. And the third is they can prosecute an offender. Each one of those requires careful consideration, and there are advantages and disadvantages. And I won't go through that again. It's in the notes, and I'd urge you to read that. Finally, bear in mind that there is the appeal to the Court of Appeal, but only if you have leave, and have a look at section 498 in that regard. Usually at this stage I'd go through the problems, but I'm quickly running out of time, so I'll add something on Moodle in that regard. Thank you very much for your first assessment. I hope that you're already starting on your second assessment, and we'll see you next week. All the best. Bye.